That stage has not yet come for purpose of bail.
That is not mentioned in the section, in this section.
Lordship,
Lordship, that is not mentioned in the section. In proviso, two things mentioned. Only the
Oh, just
report-
because it's not mentioned, that doesn't mean that you can use it, because that is to be used, that 145 is to be used only during the trial, when you confront a witness, saying
No,
that
I'm
you
not-
are,
only thing.
when you confront and contradict him.
Lordship, I'm not on that. Only thing is that if they file any document, that document must have to prove by them.
Oh,
That
they will
is why-
prove,
that-
of course.
that is why they have to file the documents which can be reported under section 145 of Evidence Act.
Oh, that is their problem, their headache. Why you bringing? You cannot bring at this. You cannot argue on that.
No, that is
That
why-
that is the
that
stage.
is
That
why-
is not the stage in bail that you can argue on that. That you can argue later on.
No, Lordship, it's a case after filing of charge sheet.
Whatever it is. So, what are the materials which can be looked into by a court while considering bail? It is the issue before us.
Lordship, let me look into few high court decisions. Of course,
Yes,
Supreme
please
Court
do
I
that.
have got, but this is not very clear. It only lays down the law.
Please do that. Please do that, because it's a very important. Also, we feel that it's very important.
Here it
Because
goes-
if we look purely on the case diary, there's so many material against you.
So then Lordship has to look into everything. Lordship cannot skip.
That's what, see.
that
See, R.K.
also.
Dev is saying, see, Nargis, R.K. Dev is saying, this court has to look to case diary, everything what is there in the case diary.
Lordship, one more thing I found.
Because the law says so,
No.
case diary or
One more thing I found, the court is entitled for perusal to enable it to find out if the investigation has been conducted on right lines. 172 is like that.
oh, that is before the,
Not against, not
But
for
that-
using of against the
only
accused.
investigation. We are considering bail after charge with evidence, but 172 is investigation. stage.
investigation stage.
Yes,
Sometimes police may go here and there.
yes,
We
Ah.
yes.
Yes.
Not a case is after,
So you argue, Nargis, we have given you sufficient hint to you.
yes, yes, definitely.
We cannot go beyond this.
I'm very much
Because
obliged to that.
hint in the sense, because these are issues which is also in our mind. What is to be done? What are the documents, what are the materials which we can look into at a time of consideration of bail?
This is perhaps an area, Lordship, I have not come across any judgment of this honorable court, at least on this point.
No, fine, then you
Yes.
assist us
Yes,
to
yes, I will try
make
to
a
do
good law on
something
that, because see,
but
whether he gets bail or not, it now on certain principle of law, it must be, so the principle of law must be clear. Then whether he gets or not, that is another issue. That is the application of the principle. But what principle we must evolve and we must adopt, we must apply,
Lordship,
that must be clear to us. If there is some vagueness in that, let it be clarified. We
Lordship,
feel that there is some element of, vagueness, ambiguity in this
this provision.
Proviso.
proviso, in this
Yes.
proviso.
Yes, Lord.
What, yes?
Yes, I got it.
Do you do some homework on that?
Yes, I'm doing Lordship.
Huh?
Still, I'm searching in this Lordship.
And do some homework,
Yes, Lordship.
spend some more time in the Durga Puja. Huh?
Again, I'll look into that.
Please do that, because this is what we felt is a very important area.
Yes,
Because
To that regard, I talk with her lots of time, Lordship.
yes, so she
I-
told me about this.
because this principle, we also want to be more clarified.
Had it
You want
been
more
not-
clarity on this.
yes, had it been not a or, if,
Yes,
Or-
yeah,
or.
had it been a comma,
comma,
Yes.
then
ha.
we could have applied adjustive generis and then apply everything.
Yes,
Yes.
yes.
Case diary, final report, the the documents that have come during the trial,
Yes.
everything would have been included. Had it, we could have.
And whatever provision of law must be in tune with the basic constitutional safeguard.
Yes.
It must be in tune with the basic constitutional norms also, and the general criminal jurisprudence of the country, unless the wording, the language is very, very categorical,
Yes.
unambiguous.
Yes. No
If it is
mystery.
unambiguous, that question of
Ah.
again bringing constitutional norm, this and that may not arise.
Then there is no
But if there is
mystery.
ambiguity, then what kind of interpretation we adopt? We must adopt that interpretation which is in conformity with the criminal jurisprudence, which is well accepted, well settled.
Here it is very clear, case diary or report.
Is there a
Now the
report?
question is, after filing of report, no case diary,
Yes,
that has to be again interpreted.
yes, yes. Can you still look into case diary once the report has been filed?
Mm.
Because by the time report has become redundant,
Ah,
Yes.
in law, the case diary has no more value.
except
Once
contradict.
till
Ah.
investigation stage, case diary has all its importance, significance.
Mm.
The moment say yes, report has been prepared, the case diary goes into background. It goes to the background. Then if that is which has gone to the background,
Whether that
can you retrieve it? Saying
Mm.
no, 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 I want to see the.
Yes. Or whether the subsequent depositions could also be considered.
Ah,
That has to be again. seen.
there again another issue.
This issue raised by your lordship earlier also, this regarding this consideration of the deposition of witness or not.
What did you? I raised it, but
But I
have you
will
given
reply-
any answer to it?
Yeah, no, lordship, because their turn, I will reply to
What
that.
do you mean by their turn? It is your duty also to
Definitely,
see
I'll reply to that.
what you are not replying also.
Their turn not yet completed.
But this is a legal issue which we also have to
Yes, sir.
address.
I talked with Ms. Jahan to that
Yes,
regard.
she
Yes.
spoke to me.
Lordship, our expert here is,
Oh,
so we all look forward to her.
highly obliged.
Now we want to see
Yes.
some more clarity on this issue.
There will be some, there will be some.
I am sure there must be some. See, if we go through, flip through, there are thousands of cases being decided in this country in lower courts. No,
In
even
under high
though,
courts.
even though yes, even though it may not be UAP Act,
Yes,
it
yes.
may be some normal act. So somebody may raise an objection. No, no, Your Honor, you cannot look into this. How can you look into this? Now is a trial stage. How can you look into this case diary? It has been discarded by the prosecution.
Mm.
Only adopt a certain portion of it. That's how they have filed this charge frames. Therefore, you can't look into that abandoned house. You have to go to a new house, which have been adopted by the prosecution. That is an old house, old farmhouse. The prosecution has built a new house.
I think there is a similar provision in Tada Pota or somewhere.
Yes,
See,
yes.
see, see.
This 43
I
T5.
found
What?
this
Yes,
in-
yes, again.
Lordship, I found in this book, but little bit time is required.
So you take your time. You, if needed, you buy more books.
I mean,
Uh,
vacation. There will be no vacation for us because of this case.
Good for